Welcome again to another In the Clip Corey Legal Zone. We're going to call it that way because we're going to change it up every time. We have to make it exciting. So in the Corey Zone, we'll call it. Actually, it's in the Corey, Larry, Walter Zone. Anyway, today we have with us, of course, the amazing Corey Silverstein, and we have. Oh, you can't talk. Sorry. I should mute you, actually. And then we have, of course, the infamous Lawrence Walters, way above Corey on the level of attorneys, just so you know, in case anyone's ranking attorneys here. And, of course, we have Dr. Chantel, the only real doctor on this channel. Corey tries to be a doctor, but unfortunately he's not. But he is a good attorney, and I just kid with him, of course, because why not? Because, you know, he's got a big head, and we're just going to make it a little smaller right now. Anyway, so today's topics are going to be, today we're going to talk about some things about California. That's what I remember from what Chantel just said, some kind of number 5.
Assembly Bill 5, which
Assembly Bill number 5.
State of California.
Has passed, and intellectual property rights.
Yes.
All right, awesome. So I'm going to hand it over to you, Dr. Chantel, since you're so good at this whole navigational thing, and you can go start from there. And welcome to everybody else who's on here, and thanks for coming in. And on to you, Doc.
Awesome. So yes, something happened in California, and Corey and Larry are going to explain why it actually does matter. Assembly Bill 5, AB 5, which is something that essentially is there to reclassify independent contractors as employees. Now, Corey and Larry are going to explain the ins and outs of this, but this is something that has already passed, unless I am incorrect, which I don't think I am.
It has passed, yeah.
Go into effect in January 2020, meaning like in 2.5 months. So this is pretty important. So I guess, Corey, do you want to just start us off and explain what is AB 5?
So, all right. So, hello. It's very nice to be here again. And I just like to note that I allowed Neil to go through his fine introduction without interrupting him.
I appreciate it.
And Neil, your hair transplant doctor just called me, and he actually told me that the hat is screwing up the implants. So you might want to, you know, not have that on too tight. So anyway, so other than talking about Neil's bad implants, what we do have to talk about today is we do have to talk about AB 5. Now, a lot of you who have been sending in messages, emails, and actually, frankly, calling my office to talk about this, I'm really happy that you guys are taking this seriously because it's a big deal. So let's talk real quick what's going on. So first of all, AB 5 applies only if you are in the state of California. So it's a California law. It is not a federal law. It is a California law.
Wait, question. If you are a California-based business, for instance, Flirt for Free is a California-based business, and you have employees that work outside of the state of California, does AB 5 apply to you?
Yes.
Okay.
But yes.
Okay.
Yeah. So let's talk. Well,
that's important.
the employee. Well, that's actually a difficult. That's
okay. We'll get to it. I started just okay.
Chantel decided to jump to the end of the presentation because she's like kind of a quick finisher like that. But
I learned it from you, Corey.
So pulling it back to the beginning before we go that far. All right. So basically, what happened, guys, is that the state of California has decided that they are going to be the leaders in the United States in terms of the destruction of the classification known as independent contractors. So when you classify a worker being someone who's doing some sort of service, you generally can classify them into 2 different sects. Either 1, you can classify them as an employee, or B, you can classify them as an independent contractor. Now, typically, many businesses have and frankly, the workers themselves have had various different reasons why they would want to be classified as a independent contractor versus employee. Now, what the state of California, though, has said is that the state of California has said that we are going to make it extremely tight to be actually an independent contractor. And so when I say extremely tight, I mean that basically what AB 5 does, and just to take it one step back, guys, AB 5 is actually just the codification of a California Supreme Court ruling that actually, I believe, it was last year, I believe that case came out. I believe it was back in last April, I believe. But regardless, so what we have now is the state of California has said that for all intents and purposes, they are going to look at you unless you are in a very, 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 very narrow group as an employee. Now, they have created a list of exceptions, and actually, as of today, the state of California openly admits that there are going to be more types of industries that will be added to their exception list. But that's basically what you have now is different industries are using lobbyist groups to petition to the state to try to get added to these exception lists. So one of the biggest things here that this is going to affect, though, is this is going to affect a employer's bottom line. Now, the difference between treating someone as an employee versus a independent contractor is approximately 20 to 30% more in increased wage costs. So what I mean by that is that if you're classified as an employee, now you've got to worry about Social Security taxes, Medicare, unemployment, disability insurance, unemployment insurance, workers' compensation, sick leave, minimum wage laws, everything. Yes, whoever just said healthcare, Madame Raven, yes, everything. And so what's happened is the state of California has basically said that they want their piece. The state of California doesn't get to share in the taxation when people are treated as independent contractors. Now they're going to really be able to share a lot more in the wealth because obviously they're going to be imposing all of the different taxes and such. So now that we have AB5, it's like, what does it mean for all of you? Well, what it means for all of you is that you can no longer just say, well, I've always treated myself as an independent contractor for whoever I'm working for, so that's going to continue. You can't do that anymore. As far as I'm concerned now, you've got to go back to square one, and every single worker relationship has to be reevaluated from beginning to end, meaning you have to do the analysis of what are the services are being provided and go through the test that's set forth in AB5.
What does the test include, Corey?
It's just such an amazing thing that you would happen to ask that question right when I moved that.
I have a list of 3 things that you can do to be your ABC test to decide whether or not you are an employee or an independent contractor. If you are free from control or direction of the employer, you can elaborate on what that means in a second, Corey.
Yep.
If you perform work outside of the core business purpose, so whatever the business, their sort of general, like if their general business is producing something, if you are contributing to content production, that type of thing. And then and this one I don't quite understand, you're going to need to explain this to us, Corey, too. If you generally engage in an independent, established trade, occupation, or business. What do those things mean?
Fun, huh?
I know, they sound really non-applicable.
So for all,
Three of those are exceptions.
This is the test.
That's the
so
test.
in order to, if you're sitting there right now and you're like, okay, am I an employee of Clips4Sale or am I an independent contractor that works for Clips4Sale? If you're trying to figure out what you are, or if Clips4Sale, for instance, is trying to figure out what their, people who they're working with, what you are, you have to go through this test. And now Corey's going to explain the 3 parameters of the test.
Okay.
So 2 things. One, the case that I was talking about before is actually known as the Dynamex case. For those of you that can't spell like Chantel, it's D-Y-N-A-M.
I can spell.
The Dynamex case. That's where this mess started. It was April of 2018, so I wasn't losing my mind. One thing to remember, though, also is that the way the statute is written is that the burden is actually on the employer. So what happens is let's say for some reason the state of California decides that they're going to look into a particular worker, the burden is on the employer to prove that they classified the employee correctly. So when you talk about the 3 tests, like you said correctly, Chantel, the first test is that the worker is free from the control and direction of the hirer in connection with the performance of the work. So what that means is, again, this is going to be that if there is any direction coming from an employer, so let's hypothetically say one of the examples that people right now are giving me in an entertainment context, let's say you have a person who is artist, a singer, and the singer wants to go out and hire a songwriter. And the songwriter goes out and she goes and, writes a bunch of songs for the singer, etc. Well, under this analysis that I've actually been reading today, the state of California would say that that songwriter is no longer an independent contractor. That songwriter is now actually an employee and would be entitled to all of the benefits under California law.
Because they are taking direction from the person who hired them to write the song.
Correct.
So if you're hiring somebody to perform in a scene, to write a song, to paint a wall, and you say, hey, I want that wall painted purple, or hey, I want this scene shot like this, like I want you to in that direction.
I think painters and plumbers are actually kind of the categories that I've been looking at as being kind of like the safe categories. So say, for example, Chantel, you were having someone come over to do some plumbing work at your house. I think those people, it would still be safe to say that the relationship was that of an independent contractor. You just saying, hey, something's wrong with my sink, come over, fix it. I think in that case, it would be very hard pressed for the state of California to say that there was an employee relationship.
Okay. Yeah, and part of it is that it has to be some kind of ongoing relationship. It can't just be a one-off, come over to my house and fix one thing. It has to be some sort of, temporal ongoing relationship.
Exactly.
What establishes an ongoing relationship? So if somebody comes over and fixes something,
the courts will tell you, it's a case by case basis.
Well,
so let me give you a practical example, since we're all in everyone who's taking part in this panel right now is in the industry, and let's talk about one particular example where we've actually already seen a case that the industry has lost, and that is in the phone sex industry. We just actually happened to finish a case that Larry and I were involved in, and the state of California, in this case, the Unemployment Labor Board, determined that a phone sex worker is in fact an employee, not an independent contractor. So we do actually are already kind of seeing which direction they're going in terms of, when you ask Chantel, well, how much ongoing control? Well, my opinion of whether or not that's really fair and the right decision really doesn't matter anymore. What matters is that the state of California is going to be veering very much on the side of relationships being employer-employee.
Right. So can you go back to the next two? So this was just the first parameter of the test. And do you have to show just one, or do you have to show all three? Like, how do we pass this test?
All three of the.
Okay. All three have to be demonstrated in order to be an employee versus an independent contractor, or vice versa. Okay. So what about parameter number two?
So let's say you survive the first parameter, which you probably won't, but if you get to the second one, the second parameter would be the worker performs work that is outside the usual course of the hiring entity's business. So in that case, this would have to be something that is basically the independent contractor is doing something completely outside of the person's business. So perfect example, I operate a law firm. Now, it just so happens that lawyers did get an exemption, so I know you can all hate the lawyers, but regardless, if I was in California and I, for example, went off and I decided that I was going to hire, like the example I gave you was the painter to come into my office and paint the walls and so forth. This would kind of be the second part of the test. The painter obviously is doing work that I don't do in my usual course of business. It's not something that I do. It's not something that I ever do. So that's kind of the best example I can give you to that one.
That one makes more sense than the other one, honestly.
Yeah, but just remember it's all three, and also and so far what California's indicated, and again this came from Dynamix, is that they are very much trending on the side of the employer-employee relationship versus that of the independent contractor.
Yeah, obviously. I mean, there's a reason why they're doing this. So, what they're trying to do is establish that.
Well, California has been, they want to really be they want to take this, like, we're the labor leaders of the country. We're the place to come where employees get treated the absolute best. You want to come to California, we're going to make sure that as a California worker, you're protected and you get all the benefits from the law that you can possibly get. But here's what the big issue is, and this is where, in my opinion, it's stupid. Because I think it's short-sighted, and it doesn't take into account how beneficial independent contractors actually are to the entire call it working public. And frankly, not every single worker wants this. There are plenty of workers out there that want to be treated as an independent contractor. They don't want to be an employee. They don't want the benefits. They would rather have that independent contractor relationship. And the state of California, despite how many people have actually protested, has basically said, well, too bad. We believe this is more about protecting employees and less about protecting businesses.
Well, I mean, don't even get me started on the state of California and their business unfriendliness, right? But let's go over the third parameter, and then let's talk about how this is going to possibly, probably directly impact the industry.
The worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So this becomes another problem. So say, for example, we can use campsite operator. If you're a campsite operator, a campsite platform, and your business is custom to having camp models perform on your campsite, then at this point, once again, we would have a situation where the worker would most likely fail the test and be deemed an employee versus an independent contractor.
So let me ask, how would this pertain to, like, listening to all this, as far as Clips4Sale goes, since we don't produce content, anything like that, as me as the owner or whatever. So it's really, I would imagine I could still treat everyone as independent contractor, me as the,
because you're in Florida.
Yeah,
well,
but what about the guy?
That doesn't matter though, Chantel, because it would still apply to any California Clips4Sale
Producer.
artist we would have to do that evaluation. So Neil, to answer your question, sort of, quite frankly, we really don't know yet. And unfortunately, what we're going to have to do, and this kind of sucks, is that most likely there's going to be a fall person at some point, and the state of California is going to, probably through the courts and the labor processes, are going to make a decision with regard to a similar kind of setup that Clips4Sale has. Now, what some of my clients are doing, and this is quite honestly, and I saw someone in the chat comments, they're rolling through fast here, is one of my clients has actually already decided that they're closing the door to accepting California models right now. They're not going to take the risk. They don't want to deal with it. They don't want to be in a position where they get fined some monumental amount of money and have to owe some monumental back taxes and all sorts of stuff. So it's already starting, and obviously this is one of the reasons why we're talking about it today. It's extremely serious. It's extremely substantial.
It's extremely already going to happen in January. Like, it's in effect.
But here's where the funny thing is, because of the Dynamics case, it's already happening. All that's happening in January is that the codification of the law is taking effect. The case law itself that anybody relies on now is the Dynamics case.
Sure.
And the Dynamics, and there's already been decisions in this regard where the Dynamics case is being relied on. Like I said to you a few minutes ago, Larry and I have already seen a case where phone sex operators, for example, are being deemed as independent contractors I got that backwards. Employee versus independent contractor. So, if there's again, this is one of those things that for people in California, I think they got it wrong. I think they got it wrong I think it's completely anti-business in the grand scheme.
That's what California is.
And in the grand scheme of things, I think what's ultimately going to happen is you're going to find a lot of people trying to find ways around it. And unfortunately, though, you're going to see news headlines over the next little while, come January even, where companies are going to get hit. You're going to see fines. You're going to see private lawsuits. You're going to see all sorts of stuff related to this.
So when you say people are going to move, I mean, think about this in terms of worker protection, right? So think about when people were trying to do safety regulations, say on set, because now let's just talk for a moment about conventional content production in California. I mean, are they going to start paying people in cash or something like that, so then there's no record? Or
well, it's interesting you'd say that, because the article that I was reading earlier today when I was preparing for today goes through this entire. Entertainers are not exempt yet. There is no exemption for entertainers. Now, entertainers are trying to, but there was an article that I read this morning. It was in the Los Angeles Times. I think it just came out yesterday or today. It's an incredible article, and it's talking about this songwriter she's like, well, what do I do with the people that are in my studio that are, while I'm singing, are, playing with all the buttons and the knobs to get the sound acoustics right? I hire those people usually on on a recording to recording basis.
Yeah.
Now, though, am I going to have to hire them as an employee? And the answer to the question, at least from what the article in the LA Times seems to suggest, is yes, those people are going to have to be treated as employees.
So if a band is playing in a bar on a Friday night, are they employees for 3 hours? Like, is that how it's going to work? And then also, what is that going to do when you think about people getting paid? So people who are used to a babysitter, a musician, a porn performer, that you get paid when the work is done, then you get handed a check or cash or whatever. Is there going to have to be like a payroll cycle? And then that's going to have to happen because then the person needs to have taxes and this because now they're an employee. So even if they're an employee for 4 hours, they're still an employee, which means the check is not going to be ready at the end of those 4 hours. If you'll
notice in the actual law, it doesn't say anything about the length of time that the person is performing the service. So whether the worker performs service for an hour or whether they perform services for a number of days, that's not one of the questions that gets asked in the test. So again, going back to the example I gave you a minute ago, where you have the sound synthesizer, I believe is the correct technical term, that comes in to help run an audio room for an audio recording. Based on what so far people are concluding is that person will have to be treated as an employee for the time period that they're working.
Right. So it doesn't necessarily, it's not that the sound engineer person is getting $50 an hour for however many hours. They could be getting $1,000 until the job is done, right? Like a flat rate. Okay, my question is more, well, yeah, it doesn't matter. However whatever they've negotiated with that person. My question and my point is, okay, so say it's a project that runs a week. It's a shoot that runs 5 days, or it's a 2-hour shoot or a 2-hour project. There's not going to be, Susan, the payroll lady, sitting there at 9 o'clock at night in the recording studio or on set in the Valley. Susan is a 9-to-5 employee who's going to come in the next day, or she's going to run payroll when she does it, or she's going to be a third-party proxy payroll service that the employer hires out, right? And my point being is that people are not going to get handed their checks at the end of the night like people are used to. Instead, it's going to be on the 1st and the 15th of the month or whatever. Now, for some people, okay, fine. Cam models are used to getting paid out, whatever that cycle is. Neil pays out very frequently, but monthly. And there's that. But for people who are working for like a day rate, that's going to come to a halt, correct?
Well, you're going to have to, what will happen is that, remember that ultimately if someone is deemed an employee, they have to then fall within all of California's labor laws, which means that you've got to, when you hire them, you've got to collect the correct documentation. You have to report it to the state. You have to collect all of their verification docs so that you can take out appropriate payroll taxes and workers' comp and everything that has to be done. And so, no, in reality, if someone was going to come in and do the job, they'll be paid in accordance with the company's payroll policies, and the company's payroll policies will have to comply with California law. So are a lot of them going to use payroll services like Paychecks and ADP and so forth? Of course, that's what they're going to have to do because it's complicated.
I think I'm looking through the questions and I'm seeing what Madam Raven is writing and I'm seeing what Lark is writing. And I think there's all of these little exceptions and things that people do. Yes, you can cash out every day on some campsites in some spaces, of course. But the idea is that cash out, that daily cash out, or is that, day rate handed over cash out, however it is, and whatever work you're doing within the business, is that going to be, is this new AB5 set of rules going to be able to be processed through on the same day? Meaning that if you are owed $1,000 for work that you did that day, that now has to go through that whole tax process before you get the $800 or whatever is going to be left over.
Correct. The company.
That's the thing and I see people saying, oh, porn exception, can't you be fined? I mean, yes, that's true. Except now, how do we do that in accordance with California law? That's the thing that is really, of course, nobody cares, right? The people who are making these laws don't consider actually the impact on the worker. And that's going to be a problem. People who are used to getting their money, like when they do the work, we're not going to have to wait because it's going to have to go through that process.
In theory, the way it would have to work would be that everything would have to taken care of well ahead of hand. So say, for example, Chantel, I hired you as an employee in California to do something for me, we would get all the paperwork out of the way before the job ever starts. So in theory, if I needed to pay you, if you insisted that you be paid the day of for the project, whatever, it still could be done.
As long as your payment, so if you filled out your paperwork in advance, so say you were a performer or you were doing work on a set or however you were doing that, if you had filled out your employee paperwork, your W-2 and your this and that and whatever in advance, and then you had said, okay, so I'm doing this girl scene and I'm getting paid however much I'm getting paid. And so they could run payroll in advance and be there with your check that is less all the taxes, and they could hand it to you then if they did in advance. So then now the next question is, how are small businesses or even large business, I mean, to think about that, shoots getting canceled, changed, times, this, all of that stuff. To have all of that stuff done in advance like that, that is a wild amount of work. Fine, but it's work to put on the employer in this instance. So even thinking about that, aren't employers then going to handle their bookings, their this, that, all that stuff differently now because they have to go, oh shit, what if this person cancels, or what if what happens?
Yes, and that is specifically what I was telling you earlier. Businesses are already making tough decisions, and there are businesses that are making preparations now to stop using California workers. Now, it is a huge expense. And there was actually, Chantel, as well, a massive group of businesses that also fought this. Now, I would tell you guys, just so everyone knows, like kind of a little bit of I'm sure you guys already know this, but it's Uber, Lyft, DoorDash. Those were the big companies that really California took the most interest in, that kind of led to this slippery slope that's, kind of continued to go faster and faster and faster. But ultimately, Chantel, this is going to cost businesses more money. In my opinion, I think the individual workers don't benefit from this at all, especially the ones that want to be treated as independent contractors. And so everyone's going to have to make adjustments. And I think what you're going to see is, again, you're going to have another example. This is just another example of the state of California chasing commerce out of the state.
Here's a question, Corey, as an LA model, and it's from Madam Raven. So if she got an LLC in Vegas, can a California company still hire her, I guess? Or can you still work if you're sort of like, how do you see the question there? What she's asking?
I know it, yeah, and we're getting that question. It's not going to matter if she sets up a Nevada LLC and then the Nevada LLC is providing the service. If the individual providing that service is in the state of California, the state of California, they're not naive. They've seen all the tricks and the spins and so forth, and they've got teams, and they have tons and tons of labor people that will look into these matters if in fact someone comes subject to a claim. What you're going to see is you're going to see a huge uptick in unemployment benefit claims. That's what one of the biggest things out of this is going to be. You're going to have a lot of people who are going to take positions that typically were independent contractor positions. They're going to leave that position. They're going to file a claim for unemployment benefits, and quite candidly, they're going to get it. That's one of the areas where we're really going to see the major significance here in the very short term.
So it sounds like this is a super complicated shit show that's about to go down. Yay.
Like I said to you before, it's like, it's not about to go down. It's happening now.
That is going down.
The only difference is that come January, it's codified. And so by being codified, again, they're taking the case law, and now you have your statutory language. So, what it's going to be, and this is what the bottom line is. We got to go back to the drawing board, and every worker type situation, you can't just blindly anymore just say, oh, it's independent contractor, because that's what it's been for the last 20 years.
1099 me.
That is not going to work. If you're dealing in any way, shape, or form with the state of California, you've got to go back, go through the whole test. It has to be analyzed, and you got to be careful, because if you look at what the statute says, and I added the link for those of you that want to read this thing. There are all sorts of different things that are put in here now in terms of penalties and fees and interest and late things, and you can get absolutely mauled and whacked with penalties and fees for not complying.
All this is going to do is cause people to move business out of state and stop taking, like you said, taking business from California workers.
I'm just, all I can do is when I see these laws is I can sit with Larry and Larry and I have discussions about them all the time. We can talk about them. We can analyze them because Larry and I aren't politicians. We're not the legislature. We don't write this stuff. All we can do is analyze it. And all I can tell you is based on just my opinion and for what I've read, I personally do not see how doing this is really ultimately going to help either side, either on the the worker side or the company side. And Larry might disagree, but that's why you've heard the expression, 2 lawyers, 3 different opinions.
Yeah, I mean, it's been an issue that the adult dance clubs have dealt with for many years. Their attempts to categorize them as employees, and a lot of them don't like it. It makes it harder for them to find work. A lot of the clubs have been driven out of business as a result of this effort to categorize their dancers as employees. So, these laws have a lot of unintended consequences. And we may see that, as you said, Corey, with the unemployment claims all of a sudden that'll become available and the flock of businesses leaving LA, less production occurring in LA potentially. It's, it could hurt their own interests. But, right now the politicians are responding to this effort to by the employees to label more and more people as employees, and so that's what we're dealing with.
Because lawmakers aren't usually the people who are actually impacted by the laws they create.
That's right.
Keep in mind, just Larry and I have spent our careers fighting government regulation. So remember, guys, we're on the other side of it. So don't shoot us. We're not. We're
just the messengers.
You're the messenger. Don't get mad at Neil either, because he's also a messenger.
So this is what I was trying to figure out. So, but basically, what I would need to figure out then would be how we are looking at all the producers, if they fall into that category or not. That's the simple thing.
The producers that are California based, right?
The California. The producers themselves have an uphill battle with hiring models. That's a whole different story for them, which is a nightmare in itself.
Yeah.
But as far as we would have to figure out then, as a company itself, as Clips4Sale, the entity, how is it that, are they still independent contractors or not? That's the question. Even a programmer, like if we have a programmer that's independent contractor that lives in California, he can no longer be independent contractor from what you're saying.
Correct. And that's the example that I gave you earlier. For example, if I hired Chantel, Chantel's a social media expert. If I hired Chantel and Chantel was in the state of California, there's a good argument that Chantel can make that she'd be entitled to California state benefits. It's really.
But not that. But then that person who's used to getting $10,000 a month as a contractor to program, now they're going to get less, but they're going to say, well, you need to add more so that after taxes, I'm still equaling that.
And that you're thinking the way someone with common sense and someone should be thinking about it. Because ultimately, Neil, like you just said, what this is going to do is this means that ultimately the worker will be paid less. Okay? So the worker, at the end of the day, the law that's supposed to be for the worker is ultimately going to cost the worker more money.
Can we go, because we need to switch gears in a second here, but I just want to, because I know that there's a wide variety of opinions on this. If somebody was going to say that this was a positive, because I know there are people in the business that are saying that this is a good thing, and predatory producers and this, that, and the other. I would like to hear what is the positive spin on this? Is there a way that people are, in your mind, effectively?
I would say that if there's
what I'm asking.
Yeah, I mean, I would say that for any producer that was paying below California minimum wage, they've got a problem now. I would say that for certain producers that maybe were not buying or having appropriate insurance for shoots, they might have an issue now, and so performers might be a little bit more happy that there's more avenues to go. There would also be more help from the state of California. So as an independent contractor, typically if someone didn't get paid, they'd have to hire a lawyer and go through a private cause of action to get their money back. But if there's a employment dispute, they could always go to the state of California, who in theory would hire them at the cost of Mr. and Mrs. Joe and Jane taxpayer.
So, basically, and I'm just kind of echoing what Raven was writing here, is that bad producers, the ones that are still there, and bad employers, those ones will get sort of funneled out through this, and the ones that are good will be impacted negatively. So yay. And then there's the question too about people who are model producers. If you're both an employee and an employer, those are probably finer point questions that really vary.
This is actually, that question is specifically why Larry and I just ordered a 50-pound container of Tylenol on Amazon. Because we're not, any lawyer who tells you that they've got this figured out right now and they've got all the answers and they can just, they don't. They're full of shit. This is something that is going to take time to work through. We've got to see what the courts are going to do. We've got to see how the labor decisions are going to come out. But regardless, this is a big deal, guys. And this is going to affect everyone in this business, if you're in California.
Blech. All right. Changing directions. And, as Corey always tells us this, and I'll just speak for him right now. If y'all have questions more specific, there's no way we can go through the ins and outs of this all the time. And he's probably doing it right now, putting his email address up there for you to reach out and contact him, because really and truly, there's a lot of stuff with this. But the most thing that we want to do is try to make you aware, and so you know that not only is it coming, but it's already happening. But today, we're also going to talk about intellectual property. And this was actually supposed to be our big topic for today, but who knew AB5 was so traumatic? So let's just dive right in here. I'm sorry for this rough segue, but it's the way it goes. So,
Chantel likes it.
I love the rough segue, right? I want one of the off-road segues with the big tires. Just kidding. So why do we care about intellectual property? Why is this important for studios, for producers? Corey and Larry. Actually, let's hear from you, Larry, because Corey is too busy trying to remember his own email address.
Yeah, happy to talk on that. I'm really glad that you guys made some time for intellectual property issues on this podcast, because it's something that a lot of people don't recognize as how important it really is for them. What we say to clients all the time is that intellectual property will be or is your most valuable asset. And it has to be properly protected in order for you to fight people that are infringing on your intellectual property rights, and for you to properly protect yourself. So things like your business reputation and your goodwill and all of your marketing efforts, everything that you put into your business is your brand name. So that trademark reflects all the years of work and all the effort that you put into your business. And so you've got to protect that brand name so that other people can't try to pretend to be you or use a website that sounds like yours or a domain that looks like your domain. You've got to protect your reputation and your goodwill through trademark rights. And you've got to protect the content that you create, whether you're a website designer, whether you're a content producer or a performer, you're creating copyrighted works. And there are ways to protect those to make sure that other people don't steal them. And when they do steal them, you want to put yourself in a position where you can enforce those rights and be in a financial position where you're able to do that. And there's ways that we can talk about where it's a lot easier to enforce those rights if you do a little bit of planning.
So what are some different types of intellectual property to get us started?
The two main ones that we should talk about that would affect the people watching would be trademarks and copyrights. So the big difference there, trademarks relate to your brand name, the name of your business, whether it's a name of a website or a studio, what have you. And then copyrights are what you create. And we can talk about the best way to try to protect those different rights and how they're typically infringed. One of the main things that we see with trademarks is domain names that are infringing on somebody's trademark, right? So you put all this money and time and effort into building your brand, and you register your domain and you're going along, and then you search your search results on Google and you see that somebody else is ranking higher than you. And you're like, who is this person? It's usually a different spin on your domain. Add some word or a different spelling or a different TLD, and then you're stuck with having to pursue this person, try to get that domain, or you see somebody else that's using a similar name to yours, and that's a real problem because you're losing business, you're losing your reputation. Somebody else could be offering services or products or whatever under your name. They could be inferior, they could be bad content if you're a producer, and that's all affecting your goodwill and your reputation in the industry. So that's why you want to lock in your trademark rights and be able to be in a position where you can pursue these people.
What happens if you're Larry Walters, and I know that there's only one of you. However, the name Larry Walters, there's probably some other person out there with it. So what if you are Larry Walters and that other Larry Walters, he might even be an attorney? Who gets the rights to that? How do you figure that out? Like, how does that work?
Yeah, that's an awesome question for this podcast, because there's a lot of performers out there that have stage names or that are using either their personal names or their stage name as a brand name. And in the United States, it all comes down to who uses the brand first. So if you have a stage name and you're the first person to think of that stage name, the first person to use it in, let's say, the adult entertainment industry, then you get to claim that as yours because you're the first to use. And if you can show that you were using a brand name before somebody else did, particularly before they got a registered trademark, then you get to lock in those rights, and you're the only one who can use that brand name in the adult industry.
What about a tricky person? So Lark is asking about, she uses Lusty Busty Lark, and she has been for 6+ years. And now apparently, tricky, there's a Lusty Busty Lara. So an A on the end instead of a K. What can Lark do about Lara?
Right. And so
Sounds
that's
like
the
an
kind
asshole.
of stuff that,
sorry, Laura.
Exactly. No, that's the kind of stuff that Corey and I, think about and talk about all the time in terms of these infringements. A brand name does not have to be exactly the same as another one to be conflicting or to be infringing. So in other words, if the two names are confusingly similar, that's the words that we use in trademark law. If they're confusingly similar, if one can be confused for the other, then that's an infringement. So in your example, I don't know how a court would ultimately resolve that. They may be confusingly similar. If you have evidence of actual confusion, in other words, if somebody is mistaking the attendee for the other person, saying, "Oh, I thought you were Lusty Lark," whatever, that's really good evidence of infringement if there's actual confusion in the marketplace. So, what I always recommend is anybody using a stage name should make sure that they investigate whether they can trademark that stage name and register it with the United States Patent and Trademark Office, because then they have ammo to be able to pursue these infringers. And it's a lot easier and a lot less expensive if you have a trademark registration.
So that's something that oh, sorry, Neil, go ahead.
No, I was going to say also, I know in our case, there's a couple of things. So like you could trademark Lusty Busty by itself, Lusty Busty Lark, Busty Lark. You can get a couple different ones. So if someone does use Lusty Busty anything, you can go after them as well because they have part of your trademark. Like we have Clips4Sale, but we have Clips, the number 4, Clips FOR. So they could do, like there was a guy, Clips4Free, who was using our Clips4. So we went after him to get the domain name because anything with that. And of course, people are always trying to spell our name wrong and like CILPS. Like whatever they could do to trick it. And of course it costs money. You have to keep going after these people. But if they're really not, this is just in our case, if no one's going to think of this spelling, you could just leave it. Obviously, you don't have to go after everything. But if it's a real confusion thing, like Larry said, sometimes it really does become annoying, especially with a name of a model or something where they're trying to trick them purposely, and they could prove that they're doing it purposely.
Yeah, and in your example, with the minor variations and misspellings and so forth, the owner of the trademark can pursue any of these infringers, even if the trademarks are a little bit different. If they add a word, for example, we do a lot of work for Chatterbait and trademark infringement, and we see constantly domain names like Chatterbait Videos, Chatterbait Free, Chatterbait Tokens. The fact that anybody's using Chatterbait as their mark, it gives us the right to pursue them for infringement. It doesn't matter if they add words, if they have different misspellings, if they have different top-level domains. As long as you're using the most important part of the trademark, the brand name, then you can pursue anybody who's adding on different elements to it or different words or different top-level domains. So, and your other point, Neil, about sometimes you let it go if people aren't hurting you. You can do that, but you got to be a little careful there because you can actually lose your trademark rights through what's called abandonment. So if you're not pursuing people, if you're just getting a trademark registration and you do nothing with it, then you can lose your rights through abandonment. So it's a good idea to police, who's infringing on your rights and try to pursue them.
Well, some of them, I'm just saying, you can go after, like, if there's 100, you can go after 40 of them, and the other might be just, no one's going to think of this, and there's no traffic to those domains. They're really not. So, but you need to basically go after somebody. So
right. As long as you're doing something to show that you're enforcing your rights, then you won't have a risk of losing them.
Because we also get a lot of people to, with clip store names, because you can only have one name as a CFRS name, studio name. But we do have some cases where the models are like, well, I had that name first. And for us, it's easy. We just go back and see what store came first and be like, well, that's the one who got it. Now, here's what you'd have to figure out. So if I started my clip store in 2006 with this name, but I never trademarked the name, and then I started it in 2018 with a similar name, who gets it, and can this person from 2005 go after this person without the trade when they didn't even trademark it? So now it's like yeah, you did. Because I always say, do you have a trademark for it? And if you do, then great. But simple scenario, this other person can't have it.
Yeah, and that's the easy case, and that's basically how Twitter handles it too. If you have a registered trademark, then you can go after these impersonation accounts and infringing accounts, people that are using the same Twitter name as your trademark. But if nobody has a trademark, then you really just have to look at who was using it first. Because you can have what's called a common law trademark, without any registration. You still have rights that you can enforce. It's just a lot harder to do so. It's a lot harder to prove up your trademark rights if you don't have a registration. But yeah, clearly if there's a registration, then it makes it a lot easier to decide who has the greater rights.
Okay, that makes sense.
So, in terms of trademark registration, it's not a terribly complicated process, but there's a lot of nuances to it. And so, we say that it's not a do-it-yourself project, not purely out of self-interest, but we see a lot of people come to us that have applied for trademarks. They've used LegalZoom or they tried to do it themselves, and it's really easy to screw up. There's a lot of ways that you can mess up a trademark application by using the wrong description of services or choosing the wrong class or the wrong specimen. And they're not things that are easy to fix because once you make a trademark application, you're saying under the penalties of perjury that all these things are true. So, the trademark examiner might come back and say, well, your specimen doesn't show your services in this particular class. You can't just submit a new specimen or change what you're doing because you said under penalties of perjury, this is what you're doing and this is how it's being used. So it's hard to fix problems that are created if you don't know what you're doing with trademark applications. So it's good to talk to a lawyer. It can be complicated, even though it looks fairly easy. If you go to the USPTO site, you do a search, nobody has this name. You can submit the application, pay online, and you're good to go. But we see a lot of time bombs that kind of are sticking in these trademark applications when people want to enforce their application or their rights if they get a registration. And then we find out that there was a problem with the way that they got their registration or the way they submitted the application, and we have to tell them, sorry, you can't enforce it. It's invalid. Somebody's contesting it. There's issues that come up if you don't do it right. So it can be a little tricky, but it's very beneficial once you have the registration. Makes it extremely easy to pursue these infringers because you don't have to prove up anything. You've got basically all the evidence you need to show that somebody's infringing if you've got a registration and if somebody else is using a confusingly similar name, particularly in domains. Yeah, go ahead.
So to sum up, then you're basically saying that anybody who's like, I'm taking my job seriously and I want to be this person, you definitely need to go and trademark your name and move on with that. Some more complicated questions though. So Lark, sorry to keep going on Lark, but she's got all these great questions. So apparently Lusty Busty Laura or Busty Lusty Laura, depending on how confusingly similar she wants to be, she lives in Australia and the real Lark lives in Canada. What kind of international, and then often is working in the United States. So what kind of international stuff can we talk about related to this? And then also, what about cross-industry? So I've heard of, and I don't know if these are just urban legends, but of cases where, there was Tara Patrick, the performer, who, Tara Patrick is actually Carmen Electra's legal name and trying to trademark those things. And they're in different industries. Like how does that work out type of thing? So if we could talk a little bit about international stuff and also different industries.
Yeah, absolutely. And those are questions that come up all the time. The international question is important because trademark rights are granted by each nation. You can also get state trademarks, but we're talking about internet usage and people that use their trademarks on the internet. So basically, we're talking about federal trademarks in the United States. You get those rights. The USPTO issues a registration. You have the rights with regard to the United States. Now, if somebody else is infringing on your rights in a different country, you can't enforce your U.S. trademark rights necessarily against them if they're only using their name or the brand in another country. It gets a little tricky in the area of domain name use because domains and websites are available throughout the world. And so that's where you have to look at, who is serving, what audience is being served by the particular services. So we get in these disputes where one domain name is in Australia and they serve an Australian audience. One domain name is in the United States, they serve a US audience. They can coexist without infringing on each other. But a lot of times they don't see it that way. They're like, look, the search results are coming up and they're showing ahead of us and people think that we're the Australian site. So in that case, you have to look at who's got what rights in what country. And there are ways you can get trademark rights in a bunch of different countries by filing what's something called the Madrid Protocol. You can get some 30, 40 different countries locked in to your trademark application all at the same time. So you file one application and you expand it to all these other countries, so long as you're actually doing business in these other countries. That way you don't have to worry about the Australian or the UK or the EU usage because you're locking in your rights in all these different countries. So that's what we do with clients. We'll talk to them about what their strategy is. Where are you offering your services? Where do you want to lock down your rights? Where do you want to protect? And you come up with a strategy and you submit applications where it's best suited for that particular individual.
So one thing just to add to all this that I think is important to note, and if you guys aren't hearing the theme here that Larry's given you, your intellectual property is an important, valuable asset, okay? You need to treat it as such. And so when Larry's saying things like, hey, you want to make sure that you're doing this right from the beginning and you don't want to I'll use the word half-ass because that's, kind of the easier way to say it. You don't want to give it that 20% effort or 30% effort and then try to go back and fix it later. You need to be taking this seriously. You need to be looking at this as you're a performer, you're a figure, whatever it is that you're doing. Get it right, protect it, treat it no different than you would a lump of cash. Treat it as an asset that you have to protect right from the start.
Yeah, that's absolutely true, and it's equally true for copyrights. People that are creating content or designing websites or logos or graphics, whatever it is, that's all copyrighted material. And you have a very difficult time enforcing copyrights without a registration. Getting copyright registration is very easy. It's $35 filing fee with the United States Copyright Office. It's not nearly as complicated as a trademark application. And once you get that registration, if somebody violates your copyrights, you're looking at being able to get up to $30,000 against that individual per infringement, plus your attorney's fees. And that's the key, because if you don't register before somebody infringes on your content, you're looking at no attorney's fees and you're limited to actual damages. What that means in plain English is that you cannot afford to pursue a copyright case against somebody without a registration, because all you're going to get is whatever you can prove you've lost from the infringement, and that can be very difficult to prove actual losses.
Like nothing.
Plus, you got to pay your own attorney's fees, and so you're talking about spending $100,000 on a lawyer to pursue a federal cause of action and proving up your own damages, which might be very minimal. But if you have that registration, the other side pays your fees, and you can be paid yourself up to $30,000 per infringement, up to $150,000 per infringement if you can show the other side engaged in willful infringement, which a lot of this is in the adult industry.
So here's a question. $35, that's not a lot of money, especially relative to what you're talking about. So would you recommend for clips producers, for instance, to just build that $35 into their production cost, and every clip they're making, they're doing that? I mean, is that wise? Especially because that stuff is frequently pirated.
Yeah, it's frequently pirated, and it makes a lot of sense. We see a lot of content producers do exactly that. It's a cost of doing business. It's not that expensive. Once you've done a couple of copyright applications, you get the hang of it. If you have a lawyer, they can typically show you how to do them at first, and then you can take it over, and the lawyer can just serve as quality control. But yes, it's not expensive. It's not complicated. But if you have that registration in hand, then when somebody does go and steal it, you've got some authority to be able to go after them and say, hey, look, take this stuff down, pay me some money, or we're coming after you. And then it's a credible threat. If you don't have a registration, people are like, oh, you're infringing on my copyright. I'm going to sue you. I'm going to come after you. Everybody knows that's BS, because you're not going to be able to afford to pay a lawyer to go to federal court over a set of pictures or one video that's not registered with the Copyright Office. But if it is registered, all of a sudden it's a serious threat.
All of that for $35. That's pretty
right.
wild, right?
35 bucks. Have you heard of
35 bucks?
Have you heard of Larry's no fee guarantee?
What is that?
Yeah, what is that, Corey? I'm not familiar with that.
I think
It's a new pro. It's a new
go
pro.
after them with you can still go after the site with the DMCA anyway, and not have the copyright. Correct? I mean, that has nothing to do with it.
Yes, you're absolutely right. You can serve DMCA notices. That's one of the limited exceptions in terms of things you can effectively do to go after pirates without a registration. The DMCA does not require that you have a registration to send out a notice to a service provider or a host or somebody that there's an infringement. But in terms of getting any money for the infringement or actually taking somebody to court, the U.S. Supreme Court has recently said that you have to have a copyright registration before you can even go to court. Then to get any money, you really have to have the registration. Otherwise, you're limited to your actual damages. So it's something you're going to have to do anyway if you're going to ever enforce your rights in court. So you might as well do it from the beginning. Yeah.
And also going back to the trademark thing also. So if you're just getting started or someone who's saying, I want to get into this industry, I want to be a performer, do some research on the name you pick, Google search it, do, like you said, do the trademark search. Even if it's a company name you want to do, whatever it is, research it, type it in Google, see if it pops up. So you know that at least you're the first one that has whatever name it is you're going to use. And this way, you're going to lock it in, and anybody coming after you is obviously second in command there with that. So you don't have to worry about it. So pick a name that no one has.
Yeah, that's a really important point, Neil. The point I wanted to make. A lot of people will do a search on the USPTO site and see that it's not taken and say, okay, now I'm good to go for a trademark application. They submit it. Then all of a sudden they get a demand letter from some other company with a name that's spelled a little differently or sounds the same or rhymes or something else, and it can still be confusingly similar. So it's not enough to just do the USPTO search and see that nobody else has the name. You got to really look into it. And most trademark lawyers will do a very thorough search of all the potential uses, state trademark databases, domain name searches, what we call common law uses, to make sure that by filing the application, you're not walking yourself into infringement action by somebody else. So that's part of the copyright and trademark clearance. You got to make sure that nobody else is going to come after you for filing the application when you do it.
Exactly.
Whew, this is some serious stuff.
This is some serious stuff. When we do these in the Corey legal zones, there's no joke.
This is no joke.
We're turning the heat up today.
We need more people to really participate in these sort of things, because it does affect,
everybody,
thousands of hundreds of maybe 100,000 people in this industry. So
there's always been, when you get into the legal business, there's one thing as lawyers that we learn very, very quickly, that unfortunately too many people take the approach of being reactive versus proactive. And what everyone should be doing, and this is just a general rule, is that take a second to make that list and be like, okay, I'm getting into this business. I've got A, B, C, D, and E that I've got to be concerned about. Get it right from the start. Take measures to protect your assets and your work right from the beginning. When I say that too many people are reactive, it's because they wait too long. They wait until something comes up, or they come to you 6 years later after they've established a brand, and they get a letter that, as it turns out, someone else was using the same brand for the last 5 years. These are all things that if you do these things right from the start, you can eliminate more than 90% of your future problems. Right. So
stitch in time saves 9. That's what my dad used to tell me, and it haunts me to this day.
Exactly.
We got another, just because we talked, about like quote unquote conventional content production, clips production. What about webcam infringements? What can be done about that? Larry, can you talk a little bit? Because I mean, a lot of people who are in clips are also camming. What can be done about live webcam infringement?
Yeah, that's a huge problem, and we see it all the time. Naturally, you know, all these shows, the private shows, are recorded and posted on these file lockers, and the webcam models are having a difficult time trying to keep control of the rampant piracy out there.
Because who owns those shows?
Yeah, well, you know, the performer absolutely owns the shows. Typically, the agreement with the webcam network says that the model retains the copyright and the network has a license to distribute it. So that's the performer that can pursue those copyright infringements, because typically the performer retains the copyrights to the content. Sometimes the networks will help them with sending DMCA notices out, as we talked a little bit about before. Some of these, you know, foreign file lockers and piracy sites don't respond to them. And that's where you got to kind of turn up the heat a little bit, as we talked about with having a registration in hand. You know, all of a sudden, if you're staring down the barrel of a federal lawsuit and hundreds of thousands of dollars in infringement damages, yeah, you might be a little bit more responsive to that demand letter or DMCA notice than if it's just, you know, a cam model sending out 1,000 DMCA notices to everybody that, you know, has a file that's infringing.
So can a cam model trademark? No. Wait, I'm confusing myself.
You're getting trademark and copyright confused now.
Yes, yes. So can a cam model? So can a cam model copyright? Say, you know, they're going cam to cam, and somebody is capping that show and then puts it, you know, as they do. Can a cam model somehow copyright that live broadcast?
Absolutely, absolutely, she can.
How?
Well, the one thing that he or she needs to do is to record it, because copyright pertains to tangible medium in a fixed expression. So basically, it has to be recorded, has to exist somewhere. It can't just be in the ether. So, you know, the best thing to do would be for the cam model to record the show and file a copyright registration. We see some models are very strategic about this. You know, they'll do shows or performances that they know are going to be stolen, and they'll record a few of them, and they'll see that they get stolen, and then they'll go after the sites that are stealing their copyrighted recorded shows. And, you know, there can be different strategies that are appropriate for each different model. You know, some have more resources than others, some want to be more proactive than others. But you can, with a little bit of planning, put yourself in a pretty good position to get the message out to these infringers that go after somebody else's content, not mine, because I'm going to be aggressive in defending my copyrights and enforcing them against infringers.
I have an interesting question, Chantel. Sorry. And
you are calling your own question interesting, Neil. I don't know.
It's going to be interesting because this pertains to the future as well. So what if I say, okay, this model and this model are the most popular models on this platform, and they make the most money. And I make a 3D model of a combination of those two girls or guys, and I have my own model now that I just created out of nothing.
Oh, like the Avatar ones.
Like,
okay.
Sort of, but more. It's getting more and more realistic now, where you almost won't know that it's a real person. But you could take the best of this, the best of that. Obviously, you're not going to call the name the same, but as me, as the guy who's like, oh, I'm really obsessed with this girl and this girl, now you have a combination of, or whatever. They could even take the same model and change her look just a little bit.
Are you describing deep fakes? Is that what you're trying to?
Something like that, where it's becoming possible to do this now, where I've seen it, you know. And
I think what you're talking about is creating a combination of multiple different images, you know, two different performers, and then the question is, who owns that content? Who owns those rights to the images, the likeness? The issue you raise is a little bit different than copyright, because you're talking about possibly an image and likeness claim, and that is that's a separate right that performers have to their face, to their appearance, to their image and likeness, that is separately protected. But let's say you're taking two pictures, and you use those two pictures to digitally morph them and come up with, you know, something that's new that looks like a little bit like both of them. And the thing that comes to mind are these apps that show what your baby's going to look like. You take two pictures and they morph them, and then it shows what your baby's going to look like. It's possible that new image could be what's called transformative, so that it's so different from the original to have its own copyright, so that you would be considered the creator.
Right.
But if it includes too much of the original images, then it would be considered what's called a derivative work, so that the original owner owns it. You can't steal, parts of a work and then claim it's yours, a few pages from a book. So it's a pretty difficult test that the courts have used, a fair use test, to determine who owns that and whether or not it's transformative. But if it's different enough, then then it could be yours. And if it's not, it could be theirs.
Okay.
Oh, goodness.
All right. So I need to remove all those
Deep fakes?
models. All those no, I have a bunch of Corys that Corey this, Corey with hair, Corey with no hair.
Corey in Hawaiian shirt, Corey in tank top.
You're I've got a little bit of a sore throat thing going today, so you're real.
Corey's Kendall Jenner, right?
You're really lucky, my friend.
So anyway, on that note, are we? You think we should wrap it up, Chantal?
I think that there are so many questions and so much stuff about intellectual property that is confusing in particular. And I think if nothing else we've learned here is that it's really an accessible thing, that, that it's not cost prohibitive. And it's about thinking in advance, and really and truly you could save yourself a lot of pain in the ass down the line if you just started kind of getting proactive with this stuff in advance. And lusty busty Lark's coming for you wherever you're at there, girl.
You have to, you've got to realize that, again, guys, this is not something that is beyond the realm of protecting yourself from. There are solutions, there are options, and there are things that you should be considering doing. Forget considering. These are things you should be doing. Protect your brands, protect yourselves. You guys work so hard in this industry to create this content that frankly, it's a shame when I see how many people don't do more. So, one thing that Larry and I always do is we're always reachable, and just basically from what I'm seeing here in our chat window, I can see this is a topic that people still want to talk about. So what of course we'll do is we will plan to do another seminar to further discuss intellectual property, because obviously, again, this is a huge issue that our audience wants to talk about, and we'll continue to talk about it, because if you guys have questions, we'll answer them. But in the meantime, guys, don't wait. Larry and I are always both available. We always make ourselves available to Clips4Sale clientele. Unless your name is Neil, then you have to wait in the back of the line.
I have to pay double usually.
Pay triple, quadruple, but
they're just jealous of you and your ring light, Neil. They're just jealous.
That's what it is. You guys don't have the ring light. You're orange and all different colors.
He's like, I'm glowing.
Green light.
Look at that. Look how beautiful.
So beautiful.
Dude, you look like a guy who just painted on some facial hair in his face.
I did. You like that? I glued it on with school glue.
It's wonderful.
Yeah. Anyway, ring lights are the best. Thank you, Lark. I'm just getting turned. I have a giant ring light too, just in case I need to light up the whole scene. But now I'm prepared for any future webinars, events, whatever we're doing. I'm going to carry this around with me everywhere I go. And it goes on your phone too. You just stick it on your phone.
So anyway, apparently the moral of the day is forget about all of the amazing information that Larry and I gave you.
Let's just talk about ring lights.
Is that Neil found a light bulb that works.
Get an LED ring light, best in the world.
Fantastic.
Listen, back in the day, we had to carry around a giant halogen thing with us everywhere. It's like, and you get a tan at the same time. It was great.
That was your breakfast this morning. What are you talking about back in the day?
All right, you two.
Anyway, okay, well, I just wanted to say thanks again to, of course, Mr. Corey. I'll call him Mr. Corey because I'll give you a little respect. Mr. Corey Silverstein, Mr. Lawrence Walters, well, a.k.a. Larry Walters, whatever you want to be called. Since you have Lawrence on your thing, I'll give you the proper.
One quick closing note.
Yes?
Sorry to interrupt you, but just on behalf of both Larry and I, just note that neither Larry or I are licensed by the state of California. So our the portion that we discussed today about AB5 is Larry and I's opinions only. And of course, if you guys want a detailed explanation or analysis from a licensed California lawyer, we always encourage you to do so. But we do have to state, because Larry and I have our ethical rules we have to abide by, that neither of us are licensed in California. So obviously, now that you all know that.
And you could probably refer someone to them?
Yes, we can.
If necessary, yes.
Okay, that's good. So they can contact you for a
But
referral.
just for those of you who are watching this later on YouTube and such, I just want to make sure you guys heard that.
Corey said that, and be like, well, Corey doesn't even work in California, so he's not licensed there.
Now, as for my real closing thought, though, between last time's seminar and this time's webinar and this time's webinar, what Chantal and I have continued to discuss is actually we are still seeing this increase in people commenting and messaging us afterwards. I've also noticed that on YouTube, our YouTube views are getting higher and higher and higher each week. So guys, please continue to submit your questions and potential topics early. We always invite that. So if there's specific things that you guys, want to talk about that we haven't talked about yet, let us know. We're going to drag Larry into as many of these as he can tolerate with us. And we're going to keep trying to give you guys as much good information as we can. So thanks as always. Keep the amazing topics coming. And Neil, don't forget that bottle of Rogaine.
Take it away. No. Oh my God. Now I just moved it out. I look blue. Now I look at that. The light might be too bright. I might need to turn it down a little bit. Hold on a minute. Oh, now it's off. See? Boom. Anyway. Yeah, I just noticed. Yeah, I didn't shave. So anyway, again, Clips4Sale brings this to you. Unlike any other platform out there, we're opening it up to different things, to to attorneys that, we give you direct access to things that you're not going to get on any other platform. So unfortunately, big head over there. You don't have a big screen anymore. It's all mine now. So again, thanks to Corey Silverstein, Lawrence Walters, and of course, the one and only Dr. Chantal for coming in. Anybody want to do a one-on-one with me, of course, talk to Dr. Chantal. We do those all the time, every week. They're awesome to do to get to know you personally and to help you out with any ways that you want to get your store, fixed up, make more money, whatever it is you want to do. So anyway, without further ado, I just wanted to say peace out to everybody. Bye.
Bye.